Hey guys, I'm Ben. I'm the pro se coach for Texas specifically. I help litigants that are lost in the Texas family law system to navigate it. It's a confusing game, it's hard, and it's exhausting. There's only one person in the courtroom or in your case that cares truly about you or your children or what's best, and that's you. Not your lawyer, not your opponent's lawyer, not the amicus, not the judge, not the guardian ad litem, not the therapist, none of them. You are your best asset. And so I encourage people to go pro se all the time, because really when you're in control of your own case, you can steer it to the best resolution for you and your children. So with that in mind, if I can ever be of help, reach out. I am specific to Texas, but I can help. And I know it's a hard game, but you can do it. So with that in mind, one of the most frequent things that I run into is restraining orders. So this happens all the time. People are very, very surprised how frequently restraining orders come into play in Texas. If you tell your friends, I got a restraining order against me, they say, what did you do? The reality is that most of the time, the judge never actually reads a restraining order. It's called an ex parte restraining order, and he flips the page over to his signature and he signs it. It's a safety mechanism, because he knows that the restraining order says that you're a very, very scary, dangerous individual. So he'll sign it so that he can cover his butt, basically, so that if something did happen, that he will have shown that he did what he could to protect the person applying for the restraining order. But you've received a restraining order. Those are called ex parte restraining orders. You were not in the room. You didn't know the hearing was happening. You were sitting on the couch. Somebody knocked on your door and handed you some paperwork and said, you've got a restraining order. So what do? The first thing you do is take a deep breath. There are reasons for restraining orders, and there are reasons people need protection from other people. Those are valid reasons. Unfortunately, most of the time, they're weapons. So we've got a restraining order. Your opponent, who I will assume is your ex, man or woman, has filed this, and it's leverage. It pushes you backward, you're on the defensive, and now you have to start proving your innocence, which is super fun to do. So you've got this, you're going to read through it. At the back of it, there's going to be an affidavit attached explaining to the judge in the court exactly how scary you are. So you're going to read it, you're going to face palm over it and say, none of this really happened, or I didn't do that, or she didn't say this, and whatever. So we've got these facts. So we have a couple of different options to respond to them. And one is a motion to dissolve the restraining order. So in that case is that I'll make up facts. Your ex says that on the night of August 15, you came to her house waving a gun around and tried to kick in the door. And so because of that, she's terrified of you. The problem is that you were with a group of 12 friends on that night, and you can prove it. With that in mind, we seek the motion to dissolve. When you have verifiable, easy proof that the affidavit is invalid, seek the motion to dissolve. Problem is that you have 72 hours to file a motion to dissolve. So upon getting it, you have to instantly sit down and start smashing out your motion. You then sign your own affidavit along with all the exhibits that are necessary to prove that you're telling the truth and that she's not or he's not. And then you file that through the e-file system in Texas, which is available to anyone, and you're in the system. So you will then get a very quick hearing, because in that situation, the judge is going to be questioning. Because if it's proven that the affidavit for the original ex parte TRO was invalid, your ex has made a fool of this judge because he took it on good faith. So you're going to get a fast hearing to go in there and say her affidavit or his affidavit is based on this night or this incident or this thing, and I can straight up prove beyond any shadow of a doubt that it didn't happen. You seek that. That TRO gets thrown out. Your victory is that your rights and privileges are simply returned, which isn't much of a victory. However, your big victory is that your ex's credibility is shot, because now nobody's really going to believe the accusations. But if it's all a bunch of, he's a maniacal drunk, she's a psycho, pill popping person, you and I both know we can come up with 1,000 allegations that we see in family law. So no matter what it is, if it's just a he said, she said, you have 14 days to sit on this. TROs expire at the end of the 14th calendar day at midnight. No matter what, if there's no hearing, it expires. But most of the time, if your opponent has an attorney, they will make sure that there's a hearing within 14 calendar days. So with that, we prepare. You have to file a response to this TRO quickly, explaining your side of the story. You prepare for that hearing, and you go in and you do your best. And that's really all you can do in family law, is do your best. It's very imposing to most people, the prospect of going in and defending themselves against allegations that are all over the map and that or feel like are either made up or embellished upon, but that's welcome to the game. So you go in, you prepare, you make your argument, you talk with either somebody like me or your friends or your family, or if you've got an attorney, great. And, we prepare thoughts and questions. We talk about cross-examination, opening statement, closing statements, your own statements. When you're pro se, you're going to call yourself as a witness. And so when you call yourself as a witness, you have to prepare a statement of facts. And so you want to walk through that. And, it's nerve-wracking. And so you want to have time to do that. You have 14 days. You've been locked out of your house, your money, your kids, your car, your everything with these restraining orders. And I hate to tell you, but they happen all the time. If your restraining order was hooked to a petition for divorce, typically there's not a lot of ugly, terrible things on those. It's you cannot come home. You cannot be around the kids or your ex. You cannot access anything. So I say it's not terrible because you just lost everything. But it's not terrible in that it's extremely temporary, and it will be explained to the court that it was simply a way to keep everything calm. I just filed for divorce. I don't want him going crazy and hurting us. So I need a TRO for this next 2 weeks so that everybody can breathe for a minute. That's one. The ones that are particularly nasty are when you guys have split, we've worked through temporary orders, or the divorce has been final for 2 years and you're sitting at home watching the ball game on a Saturday and get hit with a restraining order about how scary and awful you are, and boom, you just lost access to your kids. If you talk to them, you'll go to jail. If you talk to your ex, you will go to jail. If you show up at HEB and your ex walks by and she calls the police, you go to jail. So you have to take them very, very seriously, but you have to understand them for what they are. And they're tools and they're weapons designed to change the dynamic of who's in control of the situation. So stay calm when you get them. Read through the facts of what is alleged against you. Prepare your own case. Think about your photos, your videos, your witnesses. Where was I? Did I charge my card at a gas station when I was supposedly on the other side of town? These things are all extremely effective. The silver lining to restraining orders is that should you disprove them, it's a tremendous victory for you, because you will have proven your innocence to the court, and you will also have proven that your ex is willing to lie. And, I tell everybody all the time, there's very little law in family law. It's all perception, and it's who's believable and who's not, and you will prove your innocence. I know that we all grow up being told that innocent until proven guilty. That is not true in family law in any way, shape, or form. You will prove that you are innocent, but when you do it once, you rarely have to do it many more times. So if you've been hit with a restraining order, stay calm, read what you have, think through this. Again, if you can dissolve it, move quickly to do so. You can seek sanctions, which are a major deal in court, to seek sanctions if you can prove that it was perjury, that you've been lied against, and or then you just prepare for the hearing and you go from there.